YouTube is Tone again, back with another one. This here document is it's called the Affidavit of Walker Todd. So Todd Walker. Excellent document. You should be able to find it online. Affidavit of Todd Walker. Check it out. State of Michigan versus him. He goes in about his life as a banker and goes into fractal banking and what it is and things like that. He helps you understand what it is that the bank's actually doing, how they don't have any money. They create money off the money that's put in as a deposit. So essentially, whenever somebody puts in money, so say I give them $1, now they can lend out $10 to somebody, and they're creating that money out of thin air based on your deposit. You know what I'm saying? So you should be entitled to dividends and things like that if you want to be real. But really the point I'm trying to make is that this is the reason why you need to get a forensic audit done on these people if you're going to be charging them with fraud and things like that, charging you a mortgage for money that they never pulled out of anywhere. So what you're going to want to do is check what it is that these people did, where they got the money from and things like that. And always assume that they did the right thing, even though you know that they didn't. You want to make it appear as if you're giving them the benefit of the doubt. So you want to approach it like, hey, look, I just found out about fractal banking and criminal organizations working within the banking cartels, and I just want to make sure that my accounting was not part of any criminal acts. So I'm going to be having a forensic audit done on my particular supposed loan here, and we're going to be seeing where you pulled the money from, and you're going to have to prove that if I don't pay you, that you're going to be suffering a loss of some sort because you pulled it out of an account that you need to put it back into, right? And you're going to see when after you do that they pull that money out of their ass. So that's exactly where the fuck the money comes from. It comes from you signing a piece of paper. That's where it comes from. So here it says, generally accepted accounting principles. So banks are required to adhere to generally accepted accounting principles called GAAP. GAAP follows an accounting convention that lies at the heart of the double entry bookkeeping system called the matching principle. This principle works as follows. When a bank accepts bullion, coin, currency, checks, drafts, promissory notes, and or other similar instruments, hereinafter instruments, from customers and deposits or records the instruments as assets, it must record offsetting liabilities that match the assets that it accepted from customers. The liabilities represent the amount that the bank owes the customer, funds accepted from the customers. In a fractional reserve banking system like the United States banking system, most of the funds advanced to borrowers, assets of the banks, are created by the banks themselves and are not merely transferred from one set of depositors to another set of borrowers. So what that's saying is that they don't pull that money out of somebody else's freaking account to give to you. They can't do that. That's not legal. So what they're doing is creating the money out of thin air based on the fact that you gave them money. They're doing double entry bookkeeping. They're making your deposit look like an asset and a liability at the same time because they have to give it back to you because the shit is yours. So it's an asset and a liability. You see that? So crazy. So anyway, so what we have here is relevance of subtle distinctions about types of money. So from my study of historical and economic writings on the subject, I conclude that common misconception about the nature of money unfortunately has been perpetuated in the United States monetary and banking systems, especially since the 1930s. In classical economic theory, once economic exchange has moved beyond the barter stage, there are two types of money: money of exchange and money of account. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of the two concepts has led to persistent attempts to treat money of account as the equivalent of money of exchange. In reality, especially in a fractional reserve banking system, a comparatively small amount of money in exchange, gold, silver, and official currency notes, may support a vastly larger quantity of supposed money, right? But it really isn't money. It's just credit. It's all just credits and debits. No such thing as money. Well, I mean, there's no money that's being transferred here in the U.S. There is a such thing as legal lawful money, and that's going to be gold and silver and things like that. It's not going to be credits. So here at the end, business transactions denominated in money of account. The sum of these transactions is the sum of the credit extensions in the economy. With the exception of customary stores of value like gold and silver, the monetary base of the economy largely consists of credit instruments. Against this background, I conclude that note, despite some language about lawful money explained below, clearly contemplates both disbursement of funds and eventual repayments or settlement in money of account. That is, money of exchange would be welcome, but is not required to repay or settle the note. The factual basis of this conclusion is the reference in the disbursement requested an authorization of repayment of $95,916, the Michigan National Bank from the proceeds of the note. That was in exchange of the credit of Bank 1 plaintiff for credit apparently and previously extended to defendants by Michigan National Bank. Also, there is no reason to believe that the plaintiff would refuse a substitution of the credit of another bank or banker complete payments of the defendant's repayment obligation under the note. This is a case about exchanges of money of account, credit, not about exchanges of money of exchange being lawful money or legal tender. Right? So essentially what it is that if you're going to be playing with money that basically was made through thin air, so it's fake, then you need to accept the same type of money. So you're not going to give me a piece of paper that's worth nothing based off of money that supposedly you pulled out of your ass, backed by nothing, and then tell me that I have to give you, say, something tangible like a piece of gold with an intrinsic value, or a car, a house, nothing like that. So it's paper for paper. You understand? So that's what it is. It's really what it all comes down to. So when you do a forensic audit on these people, you're going to be able to prove that the money did not, more than likely you're going to be able to prove it. I mean, I can't say for sure, and you won't know until you do it. So if you ever have any issues with these bankers and shit like that, you want to go ahead and have your counterclaim and fraud and things like that, and make sure you have a couple $1,000 to get a forensic audit. I think it's worth it, because then you're going to be able to not have to deal with your mortgage anymore. They're not going to want to answer to that shit because they have no answer for that. And I mean, when you start looking at the books and you see that the money only really got transferred after you signed the document, then you're going to put two and two together and realize that your signature was the value in the whole situation. It starts and ends with you. Really, I mean, you're the source of the value. It's not any other piece of paper. Nothing's going to move forward until you sign it. So there's something for you to look into. Definitely get your hands on this document. Read that. That shit is awesome. So that's what I got for you for now. Until we meet again.